The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
This afternoon we have several cases. The first case is Tyler Dix et al. Versus Casey's General Store. The second case is Lucas Woods versus Charles Gabus Ford Inc. The third case is State of Iowa versus Gregory Michael Davis. And the fourth case will be submitted without oral argument, Iowa Supreme Court Attorney Disciplinary Board versus Lori Kiefer Garrison. Our first case is Dix versus Casey's.
Thank you. Good afternoon, and may it please the court. As mentioned a moment ago, my name is Rebecca Reif of the Allers-Cooney Law Firm, and with me today is also my colleague, Lindsay Vaught, and together we represent the defendants, appellants, and cross-appellees in this matter, Casey's General Stores Incorporated and Casey's Marketing Company. In this matter, Your Honors, this is a relatively complex case, and it is representative of the many interpretation and application issues which arise from the statute that is at the center of this matter, Iowa Code Section 730.5, called the Private Sector Drug-Free Workplaces Law, otherwise commonly known as Iowa's Private Employer Drug Testing Statute. After review of the parties' briefing and oral arguments, we ask this court to find not only in favor of Casey's on its appeal, but also to interpret this once called Byzantine law in a way that conforms to its purpose, which, as stated in Sims in its broadest sense, is to protect Iowa employers' right to a safe, drug-free workplace. It is not to burden our state and court system with inequitable and costly claims, which can result in monetary windfalls for employees who are undeniably caught with controlled substances in their system at work. Of primary importance to this purpose of the statute, we ask the court to make four primary findings in this matter. First, that an employer's judgment should be of primary importance in determining which employees are in safety-sensitive positions for purpose of the statute, including based on the workplace, which is in line with the statutory definition. Two, that the immunity—
Counsel, if I might, on that
Yes.
point, why does the business judgment rule apply here?
The business judgment rule applies, but that is only perhaps maybe a third reason why it may apply in this case. Overall, there is a principle of law, and it was briefed quite thoroughly by the Iowa Association of Businesses in their amicus brief, that the business judgment rule is a primarily important doctrine of Iowa law, that courts should not sit in super personnel departments over employers. And in this particular
Counsel,
case—
can you tell us how sorting cigarettes involves safety? I mean, I get it when you're driving a forklift, but I mean, do employers have free rein to define any position as safety related?
They do have rein to define positions as safety sensitive in good faith and in line with the statutory definition. And we think that is the first reason why the Court of Appeals should be overturned on this particular matter, not only on the facts of the situation, but also on the statutory definition. The statutory definition in 730.5 does not say jobs with duties that could have some kind of safety risk. The statutory definition is, in fact, a job wherein an accident could cause loss of life, serious bodily injury, or significant damage.
Give me a scenario in which Eller or McCann, they're doing their duties could result in loss of human life, serious bodily injury, or significant property or environmental
Because
damage.
they were working in a warehouse that was recognized to have a lot of heavy-duty machinery, forklifts, and they worked only in a chain link cage. And there was testimony that they left that chain link cage, but also that the walls of the cage could in fact come down so that pallets of materials on hand jacks and power jacks could come into their area. So it's very conceivable that an accident in their workplace environment could cause exactly what was stated in the statute: loss of life, serious bodily injury, or significant damage. There was also testimony that they—
Should we look at whether the safety-sensitive employee is somebody who, if impaired, it's going to increase the risk of an accident? So if I don't get it. If they're in this cage and somebody else crashes into it with a forklift, I'm still missing the connection.
They were not always in the chain link cage. They were in the warehouse environment in which they were leaving it, and the testimony in the underlying case was that they were not only in the cage the entirety of the day. That was their work site, and they did come and go from that particular cage, and their actions in their job and that particular job in the warehouse, accidents could cause loss of life. And
Is it Casey's position that everybody in the warehouse, working in the warehouse, is in a safety-sensitive position?
In that particular warehouse, at that particular work site, the employees who were assigned to be in that work site and at that work location, yes. And they were all placed in that safety-sensitive.
How is that consistent with the statute that, at least as I read it, it says safety-sensitive means some pool of employees at a particular site, which indicates to me that it has to be some sort of subset of the employees at the site. If you want to test everybody at the site, there's a statutory provision that allows for site testing.
Yes, and employers can choose between the two. Safety-sensitive employees might be a subset at a particular work site, but they also do not have to be.
But here
And
you've defined them to be the same thing.
based on the nature of the workplace, yes. And Casey's did decide as within the judgment as an employer that they were not necessarily concerned with testing an entire work site as much as they were primarily concerned about safety-sensitive functions, because those are jobs wherein something that occurs in an accident can cause much more significant bodily injury.
So, Counsel,
The statute,
other than
Sorry, Your
walking
Honor.
through an area where there were forklifts, what was the safety-sensitive issue confronting these employees?
It was the nature of the workplace,
But
and that's where it's based
specifically
on
what? What was that nature?
heavy machinery, a conveyor belt, hand jacks, forklifts coming into their area. We are focusing, I think, on the job duties of these particular plaintiffs, when what we are urging in this case is that that was a requirement read into the statutory language that does not exist. If you actually look at the language and the definition of a safety-sensitive position, it says a job wherein an accident could cause loss of life. That might be based on job duties, it might be based on workplace, it might be based on other factors. And a key tenet of legislative interpretation is that we have to look at an omission of language as much as what is in there. And in the second phrase of that particular definition, the legislature said, not only do we include a job wherein an accident could cause an accident, we also include employees whose jobs have duties in which. That's a phrase they used in the second phrase of this statute, and they did not use it in the first phrase of the statutory definition. So to read in the words job which have duties, or primarily based on the duties of that employee, is what the Court of Appeals did in this case, and they are in fact changing that statutory definition. So in this particular case, it's the statutory definition that does not limit what an employee is doing to their job duties in order to be safety sensitive. And I think we could give you other examples in this case, even beyond the plaintiffs, where you could have positions that are safety sensitive and jobs wherein an accident could cause the loss of life or serious bodily injury that's not based on work responsibilities and work duties, because that phrase is absent from the statute. You could have, like we mentioned in our brief, two custodians. One's working and cleaning windows in an office environment, one's doing it in a nuclear waste facility. Obviously, the first one is not a job wherein an accident could cause significant loss of life, but in the second one, that is a job wherein an accident, and it doesn't say who causes that accident or what the predicate of that accident is, could cause serious injury or loss of life.
But doesn't the definition include, I think Justice Waterman was touching on it, doesn't include the concept that if this particular employee were impaired, there would be a higher risk of an accident that would result in loss of life, serious injury, or what? Isn't that the concept that the statute is driving at? It's not so concerned that there's a workplace as a whole, and if somebody else was impaired and this employee was walking through, there could be a problem, right?
I think that is something that exists within the statute. I think having that particular employee being impaired could certainly become a job wherein there could be a significant and higher risk. But I think to say that that is a condition of this particular statutory definition, I don't think that exists within the statute. It's written more broadly than that. And also on that point, as we note in our brief, if we followed the Court of Appeals interpretation that reads this duties requirement into the statute, it makes another component of the statute, Iowa Code Section 730.5, subsection 9F, superfluous, because that in and of itself states that safety sensitivity is designated by the employer. And if there was not some recognition that that designation was important, why would that language exist in the statute? And in this,
But that seems to me that could be a one-way type of thing. In other words, the job has to meet a certain threshold to be safety sensitive, and the employer has to designate it as safety sensitive. If the employer chooses not to designate it as safety sensitive, then it isn't.
yeah, I think the two work together. And our argument is not only in this case was it designated by the employer and that that's an important prerequisite, and the plaintiffs in this case knew that they were designated as such, but based on what we were just discussing a moment ago, Casey's designation of these particular positions as safety sensitive were in fact within that statutory definition based on how it was written. And also, I would be remiss not to mention that we think the primary reason, in fact, that the Court of Appeals decision should be overturned as to these plaintiffs is a very important matter of statutory interpretation, which is the immunity provision, which arises under subsection 11 of this statute. As with the last issue, we think the Court of Appeals read a new condition into the statute which does not exist by stating that the employer immunity provision, which the Court of Appeals did find unambiguously applies to employers when a cause of action arises under this particular statute, is limited only to third-party conduct. That does not exist anywhere in the statute. The statute is written so that immunity applies to employers when three conditions are met. First, when the employer has established a policy in accordance with the policy safeguards of the statute. Second, when they have initiated a testing program in accordance with the testing safeguards provided for in the statute, and the employer tested or took action based on a positive test result in good faith. This is the statutory language for employer immunity, and that is what should apply when an employer raises an immunity defense. The Court of Appeals went too far by taking a demonstrative example of third-party conduct and why it is important to have this immunity provision there, and applied it and said that is the only time that the employer immunity will apply.
Counsel, so is it your position then that as long as you have established a policy and you initiate testing under that policy, even if the testing does violate the statute, that you're always immune as an employer?
Not always, because there's a third condition in the statute, and that is when an employer has tested or taken action based on a positive test result in good faith.
So if the employer violates the statute in carrying out the testing, but ultimately gets a positive test result, in that case, then the employer is immune?
Yes, Your Honor, that is what the statute says, that if these three preconditions are met upon testing, the employer is entitled to immunity. And as we stated in our brief, there is a very well-established legal doctrine that statutory immunities are to be broadly read. And in fact, in the entirety of the Iowa Code, it's very well-established precedence.
But doesn't that position then allow the employer to, we set up a policy, but then we really don't have to abide by that policy when we're doing our testing. We can violate the statute all over the place when we're actually carrying it out because we have immunity.
I don't think that would be the result, Your Honor, but we have to look at the language of the statute and what was placed in there regarding employer immunity.
Your opposing counsel suggests that, and I think it's the Ferguson case is probably a good example of it, that really what the immunity is talking about is other causes of action outside of a statutory cause of action that is expressly allowed under subsection 15.
And once again, we think that's an interpretation of the statute based on language that does not exist in the statute. It simply
Well, so how do
says
you read those two provisions together then?
that cause of action means what it says, any cause of action. That could be outside causes of action, or it could be causes of
But how do
action
you
under the
read it
statute.
in subsection 15 then that actually does give a cause of action to an employee? How do you read the subsection 11 consistent with subsection 15?
That a cause of action is created under some circumstances under subsection 15, but there is also an immunity to those causes of action under subsection 11. And this is not a completely unique statute. As stated by this court in decisions like Shoemate v. Drake University, the legislature giveth and the legislature taketh away when it comes to private causes of action under Iowa statute. There are not private causes of action for violations of statute unless the legislature has specifically created them, and the legislature can also put limits on those very causes of action. This is not the only example of that. I might point to Iowa Code Section 280.21, which is a statute that applies to school districts and says school districts and school district employees shall.
Here's, following up on Justice Oxley, I mean, under the civil remedies, subsection 15, 2B, or B, or just 15B, it says the employer has the burden of proving that the requirements of this section were met in an action brought alleging that an employer has required or requested a drug or alcohol test. You're saying actually the employer doesn't have to worry about B at all. It just can point to that immunity, right?
Well, it depends on the circumstances, Your Honor. Just like in any tort claim where there may be a basis of liability and then an employer raises an affirmative defense, there can be multiple ways to get to either liability or non-liability. So there may be a case where an employer meets the immunity provision. Then they are immune from suit. There may be cases where they do not have the immunity defense available, so then we're looking at whether or not they substantially complied with the statute, which is another point that we want to be sure to make today to extend this court's holding in Sims of a substantial compliance standard with the entirety of the statute.
Can I ask one follow-up on that?
Sure.
What was your second element, as you put it, of the immunity defense? It was the employer has to act in accord with the policy?
It has to initiate a testing program in accordance with the testing safeguards provided for under the section.
So I guess I don't understand what that gains you in the sense of if the policy has to be lawful and the testing has to be in accord with the policy, it seems to me your argument is when we comply with the statute, we have immunity. Which, I mean, that's what you're saying. And if you don't comply with the statute, then why would you have immunity? Because the testing wouldn't be in accord with the lawful policy.
It's actually not, Your Honor, and the reason is there's one word that makes a distinct difference. The district court kind of thought the same thing in this case, but there's a big difference between the terms in this statute of administering testing and initiating testing. When you look at the employer immunity provision, it doesn't say that the immunity applies when the employer has administered a test in accordance with the statute. It says it's when it has initiated a testing program in accordance with the testing protocols. So that's once they've crossed that initial threshold and initiated this testing protocol, as Casey's did in this case, they have the immunity. That is a separate question than whether in every instance under every part of this statute the employer has complied. And in fact, that is much more consistent
Which
with
then goes back to the idea that as long as you have initiated it correctly, it doesn't matter how you actually administer it and carry it out. You can violate the statute all over the place and you still have immunity.
Well, there's still a requirement, Your Honor, of good faith. I think if an employer was to just basically flout its requirements under this statute, that would not be in good faith. That would, in fact, not allow the employer to be subject to the immunity provision. And our reading of the statute in this case being based on the statutory language, I'm sorry, am I out?
Yes, you may wrap up. And
Oh, I'm sorry. It's very hard to see the timing up
That's
there.
okay. You were getting asked questions, so it's probably best to answer them.
So, Your Honors, in this case, we just urge the court to affirm the Court of Appeals decision as to plaintiffs Dix and Cattell and reverse as to plaintiffs McCann and Eller. Sincere apologies for going over time.
Well, like I said, you were getting asked questions, so, okay. Thank you. Mr. Albrecht?
May it please the court, counsel. My name is David Albrecht. I'm with the Fiddler Law Firm, and we represent the plaintiffs in this case. I'd like to start with the immunity provision, but before I do, I feel like 730.5 has kind of gotten a bad rap here. And if we pick individual pieces of the legislation and fight about it, it seems complicated. But the court does not review statutes based on its individual parts, but as it's as it's written as a whole. And when you do that, what you find is that 730.5 is not some Byzantine burden. It is actually a step-by-step guide to total immunity. So this statute as written is basically exactly as it looked in 1998 when the Republican legislature did essentially a total rewrite of the law. And if you pick this statute up, it is a little bit lengthy, but that's only because the legislature anticipated any possible outcome. And an employer thinking about doing drug testing could pick this up, look at it, and it reads like a choose-your-own-adventure book. If the employer said, am I allowed to do drug testing? Yes, you may. Subsection 3. You may, but you don't have to. But subsection 4 lets you know that if you want a drug test as a condition of employment, you, quote, shall adhere to the requirements herein. So then the employer says, okay, but in what circumstances can I test? Great question. Let's turn to subsection 8. It gives you all of the circumstances in which you can test. So then if the employer says, well, what kinds of samples can I test? Another good question, and that is defined by the statute. The statute gives every single step to the employer piecemeal. It lets the employer know what to do if it gets a positive result. It lets the employer know what to do if the confirmed test comes back positive or negative, down to the point of letting the employer know that if
Counsel,
yes,
there's been some discussion in the briefing about substantial compliance. Does the employer have to bat 1,000?
I think it depends on the pitch being thrown. So if they're violating a portion of the statute that says shall, then they are not in compliance with the statute, and then they become liable. And the reason that is because this is an enforcement provision found in the criminal code. So if I roll a stop sign, it doesn't matter that I didn't hit anyone. The code is there to enforce my conduct to make sure the overall purpose is met. Now, the statute uses the word shall a lot. It also uses the word may a lot. But it doesn't use shall gratuitously. It doesn't say the employer shall use blue ink instead of red ink, otherwise it's liable. It says things like you shall give them a copy of the policy. You shall test in accordance with the law. You shall make discipline decisions based solely on the results of the test. So it is not gratuitously strict in any way. And as pointed out, in subsection 15, the burden is on the employer because the conduct being regulated is the employer's. If the legislature was solely worried about accuracy of testing or the result of testing, there would be no statute. This statute was a conscious decision to protect private employees in Iowa from having to turn over their DNA to their boss as a condition of employment. That is a big deal. In the public arena, a urine test is a search under the Fourth Amendment. So we know that if you are going to have to turn over your DNA and all that entails, there better be a good reason and they better follow the structure of the statute. There's a portion of the statute that allows an employer to demand that the employee provide a sample under direct observation, meaning they have to expose their genitals to someone else while they urinate. That's a big deal. And if employers want the power to take these tests, they have to follow the requirement of the test. Now, Iowa's at will. They don't have to have a testing policy. They can fire anybody for any reason.
Mr. Albrecht, can you clarify a fact question for me? Can you discuss a little bit about the composition of the pool?
Yes.
How that was done? Because as I read it, there were 160 plus employees. Someone at Casey's decided we should test all of them. Somebody else said you can't do that. And then someone said, well, let's just add 10% and then test 90% and we'll get them all. Is that?
Yes, so you're talking about a back and forth between the human resources manager and the ArcPoint representative. ArcPoint is the company that did the randomization.
And I guess to make it more specific too, are the people that were added to the pool, were My understanding is some of them were in a different shift, and they were not even scheduled to be at the work site at the time of testing. Is that right?
Right, and this gets to the heart of the clearest violation that Casey's did in this case. So when they created the testing pool for this test, they included everyone at work. Now, Casey's makes a big deal in its brief that it sent the list to ArcPoint the night before the test. It did not create the list the day before the test. It created it at some far point prior. They couldn't even tell me when it had been so long. So when they decided to include everyone in the pool, there's an email exchange between the human resources manager and the ArcPoint representative. And she says, we want to test a lot of people. ArcPoint guy says, test 100%. And she says, I'd love to, but then we couldn't justify it as random. So what they end up doing is she says, here's everybody, give me 90%. And then we're going to use the other 10% as alternates. So if somebody doesn't show up, we're going to take an alternate who by definition was not chosen and have them take their place. Now again, the statute does not allow for alternates. But what Casey's did, if you look at the sum total of their violations, their list included at least 21 people who were never scheduled to be at work at the time of testing. That is the clearest violation of subsection A3.
I mean, on this random thing, I mean, maybe I'm missing something, but it seems to me the goal of that is to prevent the employer from singling out specific employees or groups of employees based on hunches or just a desire to test certain people or potentially discriminate against certain people. If they're testing everyone, it's a random principle in a sense, isn't it?
Well, I think that you could make the statutory argument that because it simply says you have to have an equal chance of selection, that there is no minimum or maximum bar for the percentage of employees. But that question is not before the court. Because what Casey's did is something that an employer would do if they were trying to escape the equal chance requirement. They included in the pool people that were never possibly going to be selected. And so by doing so, they threw off the entire randomization. So they included 21 people in that testing pool that were never scheduled to be there or who had been excused from work pursuant to the leave policy. There were people out on FMLA. That directly contradicts the requirement of 8A3. Then they told ArcPoint, what's 90% of that number? And ArcPoint said 165. Okay, so we're going to test 165 people. But on the best day, only 163 people could even be there. So by inflating the pool to begin with, and then using everybody that wasn't going to be selected as an alternate, they guaranteed to test every single person that showed up. And while on a random or equal chance analysis, maybe that doesn't affect things, it affects things because that means they didn't test in accordance with their policy, especially in using 21 employees that weren't scheduled to be there and alternates, both of which violate the statute.
Can I get back? I have another question on this substantial compliance issue. In that earlier case, the Sims case, we said substantial compliance applies to the notice provision. The notice provision has all kinds of shalls in it, and we still said substantial compliance. Is there any other reason that you can give me why the logic of Sims shouldn't extend to the statute as a whole?
Yes, because the only reason the court in Sims used substantial compliance is because there was a hole in the statute. The statute told the employer what they needed to send in post-testing notice, but it didn't say when. And the employer in Sims technically complied with the statute. They sent the post-testing notice, albeit 6 months late. So the court in Sims was saying, okay, well, what's this timing requirement then? Because there's nothing in the statute that says, within a week you got to mail it or anything. So then they said, okay, we're going to make a substantial compliance analysis. And they said, what's the purpose of the notice provision? The purpose is to give them timely information on their right to request the second confirmatory test. And if you look at the application of substantial compliance in Sims, it's actually stricter than strict compliance because NCI, the company, strictly complied. They sent the notice to Sims, who was then able to take advantage of the retest. But the court said that's still not good enough because you didn't comply with the fundamental purpose of the notice provisions. And the problem that Casey's faces is that they are taking the purpose of the notice provisions, which is accuracy, and they're trying to put that across the entire statute. But the purpose of the statute is derived by the language of the statute. And the language of the statute is clear that this is a mandatory and comprehensive scheme for regulating drug testing. When this act was first passed, it was called an Act to Regulate Drug Testing in Employment and provided penalties. And in the Tow v. Truck Country case, this court stated the, quote, manifest purpose of 730.5 is to regulate drug testing that is initiated by an employer for the purposes of influencing employment decisions. So before an employer can invoke the statutory privilege, not right, but privilege of drug testing, they have to follow the law. That was in the McVeigh case, where the only issue was whether or not the employer provided the employee a copy of the policy.
Mr. Albrecht,
Yes.
can you address how damages were handled in the Sims case? And specifically, I'm interested in the idea there that when there was a positive drug test result, the court, at least as I read it, indicates that damages weren't available, but maybe there would be fees and costs and I suppose nominal damages. Is that how you read it, and why doesn't that apply here?
It's not quite how I read it, but it's close. So I read Sims, and this is on page 340 of the decision. It's section 10. The reason that Sims specifically was not entitled to damages was because the interest at play was not adversely affected. So if we step all the way back to what it means to be an aggrieved employee, an aggrieved person, you have to have an interest that is adversely affected. Okay, and that interest is going to be different depending on what's happening. So in the Ferguson case, when this case decided there wasn't a wrongful discharge claim, the interest is the employment, but it wasn't necessarily affected by an improper drug test. It was affected by the employer's subsequent retaliatory conduct. So during a test, whether the test is authorized or not, or when the test is being conducted in accordance with the statute, the interests at play are the employee's privacy rights, that DNA that they are holding onto, as well as their bodily integrity and their employment. So if a test is not authorized, or it's not conducted in accordance with the law, then it is an improper test itself, which means the employer has adversely affected the interest without statutory authorization. Now in Sims, once we get to the post-testing notice phase, the employer has already done everything right with the test, right? So the liberty, the privacy interest has not been affected. And so when you look at section 10 of Sims, the court said that the reason Sims wasn't entitled to relief was because the employer properly tested Sims. It was undisputed that the test was authorized and conducted in accordance with the law and policy. So the only issue there was what was Sims's interest and was it adversely affected? At the post-testing notice phase, the interest becomes accuracy, right? The employer has conducted a test, has lawfully achieved or received a confirmed positive drug test result, which means under section 10, they're allowed to fire the person. Now we want to make sure that the employee has been properly apprised of his or her rights to get that second sample tested. So it's about accuracy. And Sims was eventually able to get that test, and it came back positive as well. So the accuracy interest at play with the notice provision was not adversely affected.
So I take it the distinction here then is the errors your clients are alleging were pre-test errors or during the test.
Exactly, their
errors.
authorization and conducting the test. And we see that in all of the other Iowa Supreme Court cases. In Eaton, the test was not authorized to begin with because the employer conducted an unannounced test, but that was not legal at the time. Eaton tested positive. Eaton didn't challenge the results of the test, challenged the test itself.
Counsel, so does that apply to all, you're representing all four plaintiffs, correct?
Yes, Your Honor.
Okay, and so does that apply equally then to Mr. Dix and Mr. Cottrell?
Yes, Your Honor.
Because
sorry.
they're, at least as the record stands, or as the Court of Appeals found, I think that the violation related to them was not getting the list of drugs and not being able to explain their medical history. So is that a testing problem or is that a notice problem?
So that would be a testing problem because that occurs prior to and during the test. But where the district court and Court of Appeals erred was they said, yes, we think that Casey's conducted an improper test, but not as it applied to these employees. But that's not the focus. The focus is on the employer's conduct. So once the employer has violated the statute in a way to make the test improper, it doesn't matter if it had a direct causal line to the employee's test result. So in McVeigh, the issue is whether or not you got the policy. That would have absolutely no impact on the outcome of the test. But McVeigh said that that was a statutory prerequisite to invoking 730.5. So Mr. Dix and Cattell were affected by the improper test because of all of the violations Casey's perpetrated, because when they made those violations, the improper pool, including dozens of safety-sensitive people that shouldn't have been included, including at least 20...
Counsel, on that,
Yes.
on that point, who gets to make that call?
Which call, Your Honor?
On who is in a safety-sensitive role?
Well, it would be the legislature. And I think that the court here hit on all
Well,
of...
Counsel, who gets to make it for these employees?
Well, I think that it will, these employees, as in the four in this case, that would
Correct.
be...
I mean, the legislature isn't going to opine about the plaintiffs in this case.
Correct. But what the legislature gave us is a very straightforward definition to be applied by the employer, not in a designation sort of way, but in a definitional way. So what I mean by that is, when we look at the designation part of the statute that defendants are talking about, I think as Justice McDonald talked about, the employer has no obligation to attach the title of safety sensitive to an employee that is in a safety sensitive position. They have the ability to, but that assumes that the employee meets the definition. So an employer can designate that tag, that safety sensitive tag, but only if the duties of that employee meet the safety sensitive definition. Because if we look at the definition, the first three words are safety sensitive position, not safety sensitive employee. It is occupation centric. And we know that because the definition then uses the word a job 3 times. And the only time it talks about duties, as referenced by the defendants, that's saying that a supervisor of somebody in a safety-sensitive position is also considered in a safety-sensitive position. That only makes sense if you're looking at the job duties, because we want to make sure that supervisors of employees in dangerous jobs are also free from impairment. And if we look at the Sims case, again, we keep going back to Sims, it's the only case that actually looked at safety-sensitive. And on the first page of that opinion, this court recognized that the district court found that Sims was in a safety-sensitive position, cited this definition, because Sims oversaw dangerous job functions and operated a forklift moving 10,000-pound steel coils. So the statute supports that it is based on the duties. The only case on point we have suggests that it's based on the duties, and every federal agency that uses drug testing also specifically defines safety sensitive as based on the duties. And I see I also am over, but...
That's okay. When you're getting asked questions, you keep rolling. So, okay, but you may wrap up at this moment, and then you'll have 2.5 minutes in a few minutes.
Okay. For all the reasons we have stated, we want this court to uphold the findings in favor of Plaintiffs McCann and Plaintiff Eller, and reverse the opinion as it pertains to Plaintiffs Dix and Cattell, and remand the case so that the district court can properly award the damages to Plaintiffs Dix and Cattell. And there are a couple other points, but I'll handle them on rebuttal. Thank you.
Thank you. We've got 2.5 minutes each. Ms. Reif, and I believe our clock, oh, it does go 2:30. Okay, we were thinking it didn't do 30 seconds, but it does. Go ahead.
Thank you, Your Honor, and I'll try to keep a better eye on it this time. Just in the last couple of minutes here, I wanted to just try to touch on some of the issues raised by plaintiffs' counsel, and ones that I think are very salient points for the court to consider. One is that plaintiffs' counsel referred repeatedly to the broad purpose of this statute, and repeatedly suggested, if not said, that the broad purpose is the protection of employees. But we asked the court to look back to its decision in Sims, where it stated that the purpose of this statute, and in fact the broadest purpose of this statute, is to protect employers' rights to have a safe, drug-free workplace. While we are not dismissing the need for accuracy of testing, which is what this court also stated was a more narrow purpose, to go with plaintiff's interpretation and urged interpretation of the statute as far as strict compliance, no immunity, and also to remove the word aggrieved from the statute would essentially eviscerate that broader purpose and make it practically impossible for Iowa private employers to have perfection in meeting every single one of the requirements of this, what has been called Byzantine linguistic jungle of a statute in carrying out its testing policies.
Ms. Reif, do you agree that the pool as selected was not in compliance with the statute?
We do not agree with that, Your Honor. And
Do
we
you
think-
agree that the statute requires that the pool consist of people who are on the work site at the time of the test?
The statutory language, and we think it is important to look at this in the lens of substantial compliance, which should be the standard applied
I
to the
understand that,
entirety
but the
of the
text of the
statute.
statute says the pool shall include the employees who are scheduled to be at the work site at the time of the test.
Yes,
Correct.
and Casey's believed that's what it was doing. The record demonstrates that it asked its warehouse supervisors who was scheduled to be working at the second shift from 10 a.m. to 2 p.m. of that day, and that was the list of employees that it used in order to create that list. And they used a third party, and they randomly generated that list, all of which is compliant with the language of the statute.
I thought, and correct me if I'm wrong, maybe I'm just misunderstanding the record. I thought there were 17 names on that list that were not regularly scheduled to be at the site and weren't scheduled to be there at all, and then the employer just added them to the list. Is that wrong?
That is not the case, Your Honor. They asked, Casey's management asked the warehouse supervisors for that list of who was scheduled in to be anticipated at work, and that is the list they used. And also, we would urge the court to find that all of plaintiffs' arguments regarding those testing protocols are moot because they are once again taking the word aggrieved out of the statute as far as finding a statutory remedy. There is no dispute in the record that Casey's obtained a list from its warehouse supervisors of the employees that were scheduled to be working that day and in good faith believed that to be an accurate list. And a random number generator created a list that was 90% of that workforce. All four of the plaintiffs in that case were on that list. They were not alternates. They were not added later. They were not added when they showed up for work. They were anticipated to be at work. They were out of that pool and they were added to the list, and all of them were tested consistent with that. And if we remove that requirement of causation, of requiring a plaintiff to be aggrieved by the claimed failing of the employer, that once again eviscerates the broader purpose of the statute and the statutory language in this particular statute, because plaintiffs are in a sense urging the court to find that if a plaintiff can show one tiny inconsistency with any of the testing protocols, whether it was involved with them or with another employee, which is what plaintiffs Dix and Cattell are urging in this case, that would result in remedies under the statute.
You may wrap up.
Thank you. And we do not believe that is consistent with the broad purpose of the statute or statutory language in this case. Thank you.
Mr. Albrecht.
Thank you, Your Honor. On the notion of aggrieved, the statute uses aggrieved twice, both in subsection 15, the civil remedies provision. First, in A1, it says that an employer who violates this section is liable to an aggrieved employee. But let's look at A2. A2 states that if an employer commits or proposes to commit a violation of this law, then an action for injunctive relief may be brought by an aggrieved employee. So by the terms of the statute, an employee can become aggrieved before a violation has even occurred.
Well, wait. I mean, that also covers the county attorney or the attorney general.
Correct.
So, I mean, you know, the two provisions aren't exactly parallel.
But
Normally, aggrieved in party means that particular party has to be injured by the violation they're complaining on, right?
or the proposed violation as written. And what I'm saying is both, or all four plaintiffs are aggrieved. So once the test became improper, Dix and Cattell were subjected to an improper drug test. That makes them aggrieved because those privacy interests at stake, handing over their DNA to the employer who's not law enforcement and who's going to reach back into their private life during a time they were not at work and were not getting paid and may have been in a completely different state to make an employment decision, those rights were violated by an improper test, which means that Casey's was not statutorily authorized to terminate their employment. So they are aggrieved because those privacy interests were violated without statutory authorization. So aggrieved can mean different things depending on the violation, just like depending on different statutes. And the fact that you can become aggrieved when there's simply a proposed violation shows that any interpretation that an employee must already lose their job or that they must have been fired based on an inaccurate drug test directly contradicts the language of the statute. A couple
But
brief...
it could mean you would be aggrieved if the proposed violation occurred. I mean, that's generally the case with injunctive relief. The harm could be threatened, but it still has to be harm to you, not to somebody else, right?
Right, and the harm that Casey's perpetrated in here by screwing up the entire selection process harmed Dixon Cattell. They can't say all's well that ends well. They violated the law in going through this test, and that subjected these plaintiffs to an improper drug test, making them aggrieved and making them liable for damages. That's how seriously the legislature took the privacy interests, by allowing for injunctive relief when somebody simply proposes to subject somebody to an improper drug test.
You may wrap up unless there's another question.
Very briefly on the immunity provision, good faith is not a requirement. The only two requirements are having a policy in line with the law and testing in line with the law. The good faith provision only applies to one subsection, subsumed by that is what the Court of Appeals was talking about. To the purpose of the statute, it is derived by the text, not by any other means. And my last point as I wrap up is that as written and enforced, 730.5 is clear and it is predictable. Everyone knows what's expected of them. If this court rewrites it to mean partial compliance, which is what Casey's is asking for, it becomes unclear and unpredictable. We don't know how much of a violation is enough of a violation, and the court has to continually weigh whether or not it was enough of a violation. That makes things harder on employees, employers, and their insurance companies. Thank you.
Thank you. The case of Dix versus Casey's is hereby submitted, and there will be a brief pause for the case of Woods versus Gavis to allow opportunity for some cleaning up here.